Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie?
At first glance, it looks like another day in court, but trust me, this one goes off the rails fast. And it all starts with one bold request representing herself.
All right. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Okay, now.
All right, I'm going to ask you some questions, and the questions, thank you. Questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself.
Qualified?
Hmm?
Qualified?
A what?
Qualified? See if I'm to represent myself.
Yes. All right. So how far did you go in school?
I'm in family school. Graduating. Now getting behind the finals.
All right. So here's the thing. The best thing about being a witness and what attorneys always tell witnesses, just answer the question that's asking you.
Okay.
So, how far are you in school?
Now.
All right. What year?
Sophomore class junior.
All right. And what are you studying?
Law.
All right. And how many years have you studied the law?
Say about 5 years.
All right.
I was only in the center, school litigation, and family law.
So, have you ever studied criminal law?
I never had a desire to learn about it until now that I'm going through this.
All right. So, remember what I said. Just answer the questions. Have you ever studied criminal law?
And there it is. She wants to play lawyer without knowing the rulebook. Representing yourself in a criminal case? That's not brave, that's battlefield without armor.
Studied criminal law. I think for my studies, like all civil.
All right. So, here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney. Do you understand? All right. So, do you want to have one? Can you afford an attorney?
Oh, no. Yeah.
That's yes or no.
Moment, no, because
All right. Then the next question, just the thing, just listen to the questions. All right. Are you able to afford to hire an attorney?
no.
Would you like an attorney appointed to you? That's either yes or no.
When I be able to speak to counsel, like someone to my counsel to make a decision. I don't want to rush safety. No, I don't.
You don't get a chance to choose who your attorney is. My question for you is, and I just want you to answer my question. Would you like to have an attorney appointed to represent you? That's either yes or no.
I'm sorry. I just feel like I'm being pressured and rushed. I don't.
No, you're not being rushed. This case has been going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial.
Yes.
There's not going to be at the last minute.
At this point, the judge has heard enough dancing around. She wants clarity, not courtroom chaos. This isn't a negotiation table, it's a ticking legal clock.
I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets, because in the middle of the trial, you decide you're over your head and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney,
Here's the thing. Don't start with all due respect. And let me just tell you why. No.
honorable.
This is what I want to tell you. When people say with all due respect, they're really getting upset. And usually what comes after with all due respect is not with respect. It's like when people say, let me be honest with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
And I was just wanted to say with all respect, Your Honor, the reason why I withdrew from my attorney, there was an issue with discovery since we won. When
Okay, here's the thing. I don't get into things about you and attorneys and what happened with your previous attorney unless your previous attorney is here to give their side of things.
So again, so I'm not affording my due process.
Heads up, this is the part where the judge lays down the law. No more resets, no more indecision. The courtroom is moving forward with or without her.
I don't know, you know, to me, like, you're making a judicial decision, and I don't.
It's not. It's either you want an attorney to represent you.
It'd be nice, Your Honor, if I can have some time to make a decision.
No.
Because I don't want to make the right decision if I'm going to defend myself. I'm already having lack of discovery.
My answer to you is no. If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again, previously, when you were saying you were filing your bill of particulars, I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion, and if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied. So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses. It's not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence and criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah.
So
advice or
you have been, though, because the motions that you've been filing.
Legal reality check. Filing motions is one thing, filing the right motions is another. And the judge, she's officially done playing paralegal.
Your bill of particulars, when I read it, it's really not a bill of particulars.
like I'm trying to be as effective as possible, and I'm just applying pressure on me to make a decision. You think it's really personal. Like, I don't consent to go to jury when I got my due process has been violated. I'm praying that you can hear me out. It seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received that. And here's the thing, you're saying that's not true. But listen to me, put on your listening ears. This is what I'm telling you. Your attorney, the attorney that you hired, your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney. That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery. Your attorney says you have. So, nope, let me stop you there. So what I'm telling you is this is going to trial, and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery. You don't want to answer? That's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. You don't want to answer it, you don't have to answer. Um, do you want an attorney appointed to you? Yes or no?
What pressure? I don't understand.
All right, that'll be no.
Yeah.
Ms. Ferguson, place this on the jury trial with Judge Angelini on June 16th.
I'm not even gonna talk. You know.
Sure. Go ahead.
So I have to on the record, y'all, substantiating evidence of that had not been into discovered. On May the 3rd, or May the 3rd, I received an email of some more discovery that my attorney sent me. After I filed a motion to withdraw from him, the only reason why I filed this motion to withdraw from him is because of the lack of discovery. They weren't. You know it, Your Honor. Every time we came here, it was, oh, Your Honor, and the file secret. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he's had to come in and buy a hard drive. But he made me as a client. He got a hard drive to go get it, and he still didn't continue the hard drive. Your Honor, I have substantiated evidence to prove my facts, and I filed it in the clerk of the court. So if he's willing to say what he said to you in court, if you simply discovery, I would love, Your Honor, if it was sworn, updated, stated what you said, so it could be put into.
He's an officer of the court, so he doesn't have to do a sworn affidavit.
But I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery till Saturday, 2 days before trial, 2 days before court hearing. You can look in the system, you'll see affidavit statement signed by a notary that I signed under perjury, under sworn in, and I'm telling you, I'm not trying to go to jail and lying. I'm telling the truth, Danny. He did not get any discovery until Saturday. That Saturday before court. And this is a good job. And how did you miss that? You seen some before. She smelled it, Your Honor. 1 month. 2 months after, 2 weeks after that. 1 month after. It's like he's been smelling this stuff to me. Then he's saying the older file secret. This will make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe other youth attorney, he's not probably the good fit for me. This would make me want to represent myself. So I wanted an attorney. But after I seen, I went 6 months with dealing with him, and I was very patient, very patient. I didn't say a word, I didn't get upset with him. He wanted to take a plea deal before I even got to school. And that's what really made me not upset, but made me concerned because I'm like, you're representing me, but you want me to take a plea deal without me.
This is no longer just legal drama, it's human drama. She's not just arguing her case, she's begging to be heard. And in this moment, her voice finally shakes through the courtroom walls.
My due process, right? I need to be able to defend myself. I cannot defend myself properly if I don't have all the evidence in front of me. That's all I've been trying to say.
Your acknowledgement of discovery was signed. That discovery was received on April 14th. Ms. Ferguson, could you have somebody from the state come down, please? And if you'll give him a reset form for June 16th.
You already denying the fact that we have to go into jury without my due process for the record.